I formally welcome you, ma'am.
Thank you, sir.
Everything is fine, I hope.
Yes, sir, absolutely. It's just dissertation pressure, that's all.
That is understandable. But the pressure should be positive.
Yes, sir, I've been trying. Let's see what happens.
Let us wait for another 1 minute and thereafter we will start.
All right, sir.
Once again, I formally welcome you all. We have been deliberating the idea of protection in its various manifestations. I mean, we have been delineating and exploring the different forms of refugee protection, or you may say protection for refugees, asylum seekers, migrants, internally displaced persons to a very limited extent. But as a whole, what exactly are the available forms for refugee protection under international law, particularly under international refugee law and its other important sister disciplines? On the last occasion, I have also submitted that there have been certain important steps which have been taken by notable and very, very important jurisdictions in the global north part of the world. And I was submitting that United States of America has been at the forefront in welcoming, resettling, reintegrating, and receiving refugees worldwide. Before I proceed further, my dear friends, it is equally important to understand what exactly has been the programs, policies, and other important facets of asylum systems and refugee protection systems in United States of America. And thereafter, I would be again reintegrating my entire submission with the idea of temporary protection and how United States of America has been addressing this particular issue of addressing refugee protection. My dear friends, for more than 75 years, United States of America has accepted migrants who would be identified under existing international law as refugees. In the context of, or in the conspectus of the Second World War, United States passed its first refugee legislation to manage the resettlement of some more than 6 lakh or 6 lakh 50,000 refugees or displaced. You may also call them the displaced Europeans. Throughout the Cold War, my dear friends, the United States accepted refugees fleeing from communist regime such as those in China, Cuba, and particularly many nation states of the Eastern Europe. But the United States of America's official federal effort to resettle refugees, which is popularly known as the US Refugee Admission Program, and that was not created the of 1980. My dear friends, before 1980, legislation that authorized the acceptance of refugees was enacted primarily on ad hoc basis, frequently responding to ongoing mass migrations towards the United States of America. It was not until, my dear friends, affect the all of South Vietnam to communist what we call forces in 1975, when for the first time United States began taking and accepting hundreds of thousands of Southern Asian refugees in a particular what we call year, and that ultimately impelled the US Congress to establish a more standardized, I should say, a system of refugee reception in the United States of America. In 1980, legislation, my dear friends, and that is the US Refugee Act of 1980, and that has been signed by the President G. Carter at that point of a time, established permanent procedures admitting and resettling refugees in the United States of America. This particular piece of legislation, my dear friends, has also incorporated the official definition of the term refugee, increased the number of refugees to be admitted annually to 50,000, and granted the authority to admit additional refugees in emergency situations or during emergencies or in emergencies. Since that law passed, that is the Refugee Act of 1980, the United States has admitted more than 3 million refugees. Now the question arises that the heavy of accepting refugees from and start program in 1980, approximately 11,400 in 2021, up to last year. Levels of refugee admissions were dramatically throughout the time period, falling through the 1980s and spiking again in the 1990s after the collapse of the Soviet Union. It had also what we call some kind of impact on the refugee program, the US refugee program. My dear friends, annual American ceilings of refugee what we call admissions are
Sorry to interrupt you. We can't hear anything, sir.
congressional approval. Am I audible to all of you? Yeah.
No, sir, your voice is breaking brutally,
Am I
sir.
audible to you?
Sir, your voice is breaking, sir.
Yeah, thank you. My dear friend, my voice is breaking. Okay. Let me reconnect. I am extremely sorry, my dear friends. Am I audible to all of you?
Yes, sir.
Yes, sir.
Yes, sir.
I
Yes.
apologize for the inconvenience. It was beyond my control because of the erratic supply of internet since morning today. So that has caused this disturbance. I hope my voice is not breaking now.
No, sir. Now it's not.
Yeah, thank you, brother. My dear friends, following the 9/11 attacks, President George W. Bush suspended refugee admissions for several months in United States of America. President Bush at that point of a time or immediately after 9/11 cited national security concerns. From 2001 up to 2015, my dear friends, caps on refugee admissions in United States of America stayed between 70,000 and 80,000. However, both the Bush and Obama administrations regularly admitted fewer people than the ceiling allowed. I recall, if I am correct in my recalling, my dear friends, you can correct me. In 2016, President Obama increased an earlier approved ceiling of 80,000 to allow an additional 5,000 refugees as part of an effort to address a growing migration crisis caused by worsening conflict in Syria. As humanitarian crisis elsewhere grew more dire, including in Afghanistan, Iraq, Obama administration proposed that the United States set to ceiling of more than what you call 1 lakh refugee admissions for the fiscal year in a single year, which I have also pointed out on my earlier submissions. And in this particular year, it was the year, if I am correct in my submission, that is 2017. In this particular year, we have witnessed a lot of resettlement of refugees in United States of America. But the subsequent president, I am talking of, President Trump, reversed Obama's, proposed ceiling by capping the number of refugees allowed in United States of America in the fiscal year 2017 at 50,000. He lowered this ceiling further to 45,000 in the year 2018, unfortunately, and then 30,000 for 2019 and 18,000 for 2020. Trump administration argued, my dear friends, that the reduction was necessary to direct more government resources to the backlog of applications from nearly 800,000 asylum seekers who had reached the southern US borders. Despite critics, despite all kinds of criticism, my dear friends, particularly for countering that the asylum and refugee programs have little bearing on one another, President Donald Trump at that point of a time set an even lower ceilings of the 15,000 for the fiscal year 2021, by far the lowest cap since the program is started. So you can very well understand this has been the attitude of various administrations in the United States of America. If you take into account, my dear friends, attitude of the current president of the United States of America, Joe Biden, then the President Biden has promised to reverse this downward trend. In May 2021, he revised the annual admissions cap to 65,000 or between 60,000 up to between 60,000 to 65,000 for the remainder of the year. And in October, he doubled the ceilings for the fiscal year 2022. I mean the current year, up to what you call, 1,25,000, with the majority of the admission slots allocated to refugees from Africa and Southeast Asia. Even further, my dear friends, I would like to submit at this stage that it is unclear how quickly Trump-era reductions can be reversed. The United States accepted fewer than 12,000 refugees in 2021. Some advocacy groups argue that the annual cap should be proportionately reflect, or it must be reflected in the number of refugees worldwide, whatever the amount of refugees that has been accepted in United States of America. So this is very, very important, my dear friends, and that under all circumstances, that should be what we call critically appreciated. Under the 1951 UN Convention relating to the status of refugees and the 1967 additional protocol to the 1951 Convention, my dear friends, states cannot expel or return a refugee to territory where his life or freedom would be threatened on account of his race, religion, nationality, membership of a particular social group or political opinion. And this is a well-established what we call fundamental principles emanating from the definition that has been couched in journal terminology in 1951 Convention. And this is time and again I have been submitted. But we should not forget, my dear friends, without indulging in some kind of an intellectual platitudes, this is my humble submission to all of you, that individualized refugee determinations for persons outside the United States of America and political asylum adjudications for those within the United States of America exclude vast categories of persons in genuine peril. I still remember that in 2011, less than 1/4 of the world's 72 million forced migrants, those displaced by violence, conflict, and development projects, natural disasters and hazards, met the refugee what we call definition in United States of America. However, nothing prevents contracting states from extending rights and benefits beyond those have been set forth in the 1951 Refugee Convention. The Organization of African Unity, for example, adopted a broad definition of refugee that covers persons compelled to leave their nations by external aggression, occupation, foreign domination, or events seriously disturbing the public order, as I have already submitted on various occasions, particularly when we deliberated the refugee protection within the regional context. Cartagena Declaration, my dear friends, adopted by 10 Latin American nations and subsequently approved by the Organizations of American States General Assembly, that ultimately enlarges the refugee definition to cover persons whose lives, safety, or freedom have been threatened by generalized violence, foreign aggression, internal conflict, massive violations of human rights, or other circumstances that have seriously disturbed the public order. That is the mandate of Cartagena Declaration as per the definition that has been provided under the declaration. But it is a non-binding what we call instrument, but it has become the part of the national policies of many of the Latin American nation states. However, the European Union has created a subsidiary legal status for non-refugees at risk of serious harm in their countries of origin. And that should also be taken into consideration, my dear friends, because the subjective human rights are conceived as powers or faculties that inhere in individuals. And that is not only inherent, but inherent in the what we call the idea of individualism. Still, it is incongruous to note that the Refugee Convention, the 1951 Refugee Convention, Convention adopted in response to the mass displacement caused by the Second World War requires case-by-case refugee determinations and cannot be used to protect groups at immediate what we call risk. Certain rights apply to groups, my dear friends, as in the collective right to self-determination. I can give you this example, and group memberships can also serve as an effective proxy for individual rights violations. In United States of America, therefore, my dear friends, we have also witnessed a very, very important development. And that development, though it has recently expired, but it was a development which is popularly known as the Lautenberg Amendment. Lautenberg Amendment, my dear friends, in the United States of America represented a form of group protection, establishing a presumption of refugee eligibility for persons in historically persecuted groups, particularly religious minorities, particularly from the former Soviet Union, Southeast Asia, and Iran. The amendment, my dear friends, is the burdens of what we call proof for refugee applicants from these what we call groups and allowed beneficiaries to apply for adjustment to lawful permanent resident what we call status after 1 year, after completing 1 year residency in United States of America. Therefore, the US Refugee Act of 1980, which I have earlier mentioned, my dear friends, under what circumstances this particular piece of legislation was passed in the United States of America, enshrined the obligations and standards set forth in the Refugee Convention into domestic law. Under current law, the United States cannot admit refugees as a group. There must be individual screening under all circumstances, and it cannot, the United States of America cannot admit as refugees non-citizens displaced by generalized violence, civil war, human rights violations, man-made or natural disasters, or those at risk of what we call persecution, but not on enumerated grounds as per the mandate of the US Refugee Act of 1980. The experience I can also share of some of the refugee groups. The experience of the Mexican and Central American asylum seekers exemplifies the difficulties faced by the endangered persons that seek protection in the United States of America. Over the last more than 5 years, US Border Patrol arrest of accompanied minors who are primarily from Mexico, Honduras, Guatemala, and El Salvador have increased dramatically. That has also been what we call reported by the United Nations High Commissioner for Refugees. Yes, Mr. Omja.
Sir, sorry to intervene.
No. Most welcome. Please go ahead.
Sir, actually, my question here is with regards to United States of America. Sir, we know that there are Native Americans, like the ones who are called the Red Indians. They reside in the territory of United States of America. So, sir, since they have been time immemorial being living there in America, so are they considered as citizens of America, or they have not been granted the citizenship and are being treated as non-citizens?
Reframe your question, Mr. Om.
Sir, for example, there are indigenous people residing within the territories of America, or let's say Australia as well. So, sir, as we know that there was a European intervention in both these countries, Australia and America, where the Native American population just got decreased, and now in these countries, I believe there is no citizenry rights for
So
these
may
people.
I'm so sorry, you want to intervene.
Yeah, sure.
Yeah, please.
Sir, with my understanding of what Om is saying, basically is trying to identify whether these indigenous people have been given the citizen rights, which I think they have, because they even have affirmative actions for these people, because primarily it was their land which was stolen away from them, and there were massive killings and all which happened. So they are protected as well, and there are a lot of plans which have been set up for the community appraisal, and there are some subsidiaries and grants also provided to such groups, red Indians, if you may.
Yeah. Well, thank you very much, Mr. Om Jha, and I also appreciate the response rendered by Ms. Sajul. Let me further supplement both the observations as well as questions. As a student of international refugee law, it is our collective responsibility to understand. It is our collective duty to understand, my dear friends. When entire brolly of protection, entire compendium of protection, legally binding obligations, where the written constitutions, everything fails, even then there are rooms for protection available to refugees, to asylum seekers, to immigrants, to migrants, to foreigners and non-citizens. As Ms. Sajul has also pointed out, the indigenous people has, and they have got the better claims than the immigrants and migrants. It is a well-established fact that so far the protection for the indigenous people are concerned. We have only one what you call subcommittee or subcommission that has been constituted under Article 27 of ICCPR. Lot of juristic writings are available in the domain of human rights or international human rights law, but indigenous peoples have always been neglected. Sometimes indigenous people are also known as the tribal people in India or in South Asian nation states. But when we are talking of international refugee law, my dear friends, when all laws fail, then international refugee law come into picture. It is the beauty of the international refugee law, my dear friends. Then we are not able to get any kind of a protection under various provisions of the different laws. Then international refugee law is invoked, and even in situations where we find that the international refugee law is not able to protect or to grant any kind of a protection to people who claim assistance and humanitarian treatment under the various provisions of the international refugee law, then it is the customary international law that comes into picture. But unfortunately, we have been witnessing a new kind of emergence, and that has given a new idea, and I would address it subsequently. I am going to deliberate with a one particular what you call doctrine that I have designed on the basis of my 1 week's study, and how I have been following the emergence of a new class of refugees, and that is known as Ukrainian refugees. For the last 1 week, I have been delineating and deliberating the state of behavior towards Ukrainian refugees, particularly from the global north jurisdictions that I would come subsequently. And I have also given it a new what you call approach. But so far your question is concerned, my dear friends, Mr. Om, it is equally important to understand that the non-citizens, indigenous people, foreigners, they are also protected under the law of United States of America, and particularly the Constitution of United States of America. And that is why we have been deliberating the idea of the temporary protection. They have been getting the idea of, or getting, protection or some kind of, protection is being extended to such class of, people, or this kind of, classes of, people who are not considered as nationals, as citizens, or the lawful what you call residents of a particular geopolitical entity. Then it is the constitution and constitutionalism that comes for their rescue. And that is why they are getting all kinds of rights, particularly the right to human dignity. Without dignity, no human rights can succeed. And that is why, if you take into account the US temporary protection programs, these temporary protection programs of the United States of America are exclusively based on, or primarily based on executive discretion. But executive discretion cannot violate the principle of human rights and human dignity. And at the same time, my dear friends, these premises of executive discretion have not been overhauled for nearly 30 years, or nearly what you call 30 to 40 years. That is why temporary protection becomes very, very important. At the same time, we should not forget, my dear friends, that the parole is the primary vehicle for offering physical entry to non-citizens for emergency and humanitarian reasons in the United States of America. Prior to the enactment of US Refugee Act of 1980, my dear friends, the United States used a parole to admit large refugee populations. Subsequently, US Congress, my dear friends, extended refugee status to most of these what we call groups of the non-citizens or indigenous people, which is popularly known as the lawful permanent resident status, LPR. Under this particular LPR mechanism, any person not a citizen of the United States of America who is residing in the United States of America under legally recognized and lawfully recorded permanent residence as an immigrant would be allowed to stay in that under this particular category of LPR, I should say. It is also known as permanent resident alien. It is a later what we call expression that has been invoked and invoked by various agencies, non-governmental organizations, non-governmental international organizations, and permanent resident alien was also what we call enriched with other important expressions like resident alien permit holder. And today, my dear friends, in the popular parlance, if you recall, and you will definitely understand it immediately, and that is today known as the green card holder. So the green card holder is the latest what we call expressions. This is the new what we call generation that has been using this kind of a expression. Otherwise, earlier it used to be known as the permanent resident alien or resident alien permit holder. My dear friends, US Refugee Act of 1980 formalized and made the US Refugee Resettlement Program the primary vehicle for refugee admissions. US Refugee Act of 1980 limited the use of parole to individuals, not groups. And it has also created a presumption against parole for refugees and set narrow eligibility criteria. Narrow eligibility criteria should be understood, my dear friends, as urgent humanitarian reasons or significant public benefit. However, the parole does not, my dear friends, in itself lead to LPR status, as legislation to adjust paroles to LPR status requires a super majority vote in the US Senate and the US Department of Homeland Security, that is popularly known as DHS, does not consider the temporary protections recipients to have been admitted or paroled as is required to adjust to the LPR status in the United States of America. My dear friends, temporary protection status, which is popularly known as TPS. This kind of a TPS applies to non-citizens from designated foreign status to regions within the states. Temporary protection status, my dear friend, does not cover nationals of the designated states who entered the United States of America following the effective date of the designations, even those who have fled great amount of great or highest thresholds of persecution in their country of origin. My dear friend, temporary protection status further does not permit recipients to petition for the admission of the close family members. And additionally speaking, my dear friends, it also applies to only to those persons who have been designated or who have been hailing from the designated states, and not to those from non-designated states who are in substantial need of protection. In the event of extension or redesignation of the temporary protection, status beneficiaries must re-register, and some do not, and thus or therefore lose ultimately their status as TPS. Like United States of America Refugee Program, temporary protection status, my dear friends, affords employment authorizations as well. Unlike refugees or asylees, temporary protection status recipients do not receive refugee resettlement benefits and are not deemed qualified for most federal or federal public benefits, whatever the benefits have been designated. Temporary protection, therefore, needs to be distinguished from complementary or subsidiary form of protection. The legal basis for which is rooted in human rights obligations of the non-refoulement, as it has been enshrined under Article 3 of the Torture Convention, under Article 33, subclause 1 of 1951 UN Convention relating to the status of refugees. Unlike temporary protection, my dear friends, complementary or subsidiary forms of protection are not normally emergency or provisional in nature and are applied on an individual case basis rather than to mass movements of persons. My dear friends, complementary protection usually also applies, or that also implies, I should say, that the person is already in the territory of the asylum state and thus does not give rise to questions of admission. Therefore, accepted grounds for complementary form of protection have so far involved prohibitions on return to the risk of torture, cruel or inhuman or degrading treatment or degrading kind of punishment, unfair trial, or the arbitrary deprivation of certain important rights, including a right to life as the most important non-derogable rights in the entire schematization of international human rights law. Further, I would like to say, my dear friends, on this particular, understanding that the some national temporary protection schemes should not be confused with temporary protection, as this term is used in the context of the mass influx of refugees as a means to suspend convention obligations, as we have been, witnessing for the first time in case of what you call the Syrian refugees, as well as in case of Rohingya refugees. And now we have started what you call assessing this idea of what you call of temporary protection in the case or in the situations of the Ukrainian refugees. Therefore, temporary protection is an exceptional emergency device, as per my understanding, to respond to an overwhelming situation where there are self-evident protection needs and little or no possibility, I should say, or there is no possibility to determine such needs on an individual basis in the short term. Therefore, the temporary protection, my dear friends, under national laws can be a legal category, and or rather I should say on the basis of discretionary exercise of the executive power, which have typically been used to what we call extend protection to broader categories of persons in need of some form of international protection other than the convention refugees. Convention refugees are those refugees who have been protected under 1951 Refugee Convention, although this is not always the case. Some national what we call temporary protection visas, my dear friends, do not cover admission to the territory, but rather apply to those what we call already in the territory, and those, I mean, who cannot be returned in the short term to their what we call country of origins, where they feel that their life likely to be imperiled upon their what we call return. Therefore, it becomes necessary to understand that the temporary protection is distinct from complementary protection, which is a legal basis offered after recognition of individual protection needs and a determination of their nature. My dear friends, temporary protection by definition involves a group assessment of international protection needs based on the circumstances in the country of origin, where complementary protection measures apply to individuals whose protection needs have been specifically vetted, regulated, examined, analyzed. But at the same time, my dear friends, both temporary and complementary protections should ensure adequate standards of treatment for the beneficiaries. The provisional nature of the temporary protection, my dear friends, its short what we call duration, and especially its use with large groups, warrants the use of the minimum standards which have been contemplated in the core, particularly 9 core international human rights treaties, including the refugee instruments. Therefore, complementary protection measures, on the other hand, my dear friends, provide a definitively stable treatment immediately upon recognition of the individual's protection needs. And due to these kinds of circumstances and other what we call significant differences between the two concepts, my dear friends, the provisional device of the temporary protection should be clearly distinguished from other forms of complementary protection provided in individual what we call emergency situations. If you take into account some of the important contributions, my dear friends, which have been appreciated and which have been further developed by the European Council on Refugees and Exiles in the context of what we call of temporary protection, which is popularly known as ECRE, European Council on Refugees and Exiles. My dear friends, ECRE of the view that the temporary protection represents a reasonable administrative policy only in an emergency situation where individual refugee status determination is not immediately what we call practicable, and where temporary protection's implementation will enhance admission to the territory. But this line of argument has not been bought by the South Asian nation states, particularly Pakistan, India, Sri Lanka. Because if you take into account European Council on Refugees and Exiles, that has emphasized that the temporary protection does not reduce the need for a supplementary refugee definition in Europe or elsewhere. Nor should it be applied in any way which erodes existing form of protection, such as the 1951 UN Convention relating to the status of refugees. Therefore, ECRE proposes that the definition of an emergency requiring the activation of the temporary protection should relate both to the large scale of the outflows and the consequences of a sudden large scale arrival at a receiving country. On these conditions, my dear friends, European Council on Refugees and Exiles supports the view that the European states should cooperate as widely as possible to develop common standards of temporary protection, as well as the complementary mechanisms for sharing responsible among states. But unfortunately, my dear friends, this kind of an idea has not been appreciated by the SARC jurisdictions. And SARC jurisdictions are of the view that the entire refugee problem, as per the estimation of the SARC jurisdictions, the refugee problem has always been perceived by the SARC jurisdictions as a problem which can only be resolved by invoking the idea of bilateralism. And it also includes all forms of refugee protection. And that is why, despite the fact that we have been talking the cultural integration of the SARC jurisdictions, we have been talking of ethnic integration of the SARC nation states, we have been talking in terms of the artistic integration, or in the field of arts, the integration of the SARC nation states. And to some extent, we have been successful in integrating the education field among the SARC nations by establishing this kind of a intergovernmental organization, which is today known as the South Asian University. In the field of what we call of education, we are striving to integrate our juridical understandings. But in case of the refugee protection, we are still what we call we have been lagging a lot, I should say. And that is why, my dear friends, in the field of temporary protection, we have not been able to integrate the SARC region, because temporary protection should last for a limited what you call period, or for a period between 6 months and 2 years, sufficient to deal with the consequences of a sudden large scale arrival. Refugee problem has been politicized in the SARC what you call jurisdictions, despite the fact that temporary protection warrants only 6 to what you call 6 to 2 years duration. Even then, we are not in a position to invoke temporary protection. And after this fixed period, the legal status of the persons affected by the emergency should be regularized by the granting of a sense of what we call of security, or to secure some kind of a status, or TPS, temporary protection status. My dear friends, people or refugees or persons under temporary protection should have access to individual refugee determination procedure as soon as it is practical and certain, and certainly prior to any subsequent return. It is one of the line of arguments that has been again proposed by the European Council on Refugees and Exiles, that the guiding principle that the rights attached to temporary protection must be proportionate to its duration. States therefore should declare at the very outset, at the very beginning, that the time frame which they intend to apply, and therefore the rights should be afforded during that particular period of time. because the rights afforded should include as a minimum what you call guarantee the rights to family unity, education, social assistance, humanitarian assistance sufficient to cover basic what you call requirements, including healthcare, engagement in gainful employment. It is one of the important articles of the 1951 convention. Identity documents under article 30, 28 and 30 what you call 31, as well as an explanation to both refugees and citizens of the host states of how these rights may be exercised. This particular organization which I am talking of in the context of Europe, but the principles which have been developed by this very organization, that is European Councils on Refugees and Exiles, also what we call believes that the written following temporary protection should only take place multilaterally in conditions of safety and dignity, with assistance and counseling, and on the basis of an independent and impartial human rights assessment of the people who are likely to be repatriated to their country of origin. ECRC, my dear friends, therefore urges that the principle of democratic transparency be respected throughout, involving consultations with or inter alia non-governmental agencies and the refugees, what we call themselves. They should also integrate their voices in any kind of decision. Therefore, we can say at this stage, my dear friends, and thereafter I will, answer those particular what you call questions which I have raised in response to the Ms. Sargans and Mr. Omjha's what you call response. That is, I mean, in the context of Ukrainian refugees. Let me submit it like this. So far, temporary protection is concerned. My dear friends, temporary protection is one of the many mechanisms for limiting what we call refugees' access to protection, which also includes extraterritorial processing, offshoring arrangements, and these what we call substitute protection mechanisms, if I am allowed to what you call address them like this, limit primarily access to effective protection under the convention, 1951 UN Convention relating to the status of refugees. My dear friends, temporary protection policies have obstructed successful integration. Because of the political hierarchy in many jurisdictions, including South Asia, policies that place limits on learning the language, that limits access to education or healthcare, and that restrict movements radically reduce the refugees' ability to function normally in the new what you call communities. The emotional distress is another important what we call, and today we have been talking of the mental health of the refugees. Then it becomes very, very important to deliberate on this particular aspect of emotional distress. Emotional distress that is caused by the separation of families and the lack of certainty about the future further disables refugees' ability to integrate. Therefore, temporary protection policies undermine the stated goals of promoting greater integration and assimilations in the host what we call communities or in the host countries. The internationalization, my dear friends, particularly of Western refugee policy, Western refugee policy development, and that is evident in the extent to which countries are able and willing to import harsher policies. And these harsher policies are generally perceived to have been successful. And that is the what we call travesty of refugee justice. This is how we should what we call revisit the entire mechanism of temporary protection policies and their internationalization and the reception thereof in the global South jurisdictions. This is what, my dear friends, I wanted to submit on temporary protection mechanisms, but this is not the end. Rather, this should be perceived as a beginning of the new understanding. Because In higher education, we do not conclude anything. We always what we call start afresh. We try to what we call germinate the seeds of the new juridical proclamities to ponder over. Now I come to that very question which I had raised in the context of what we call of Ukrainian refugees, and that would also be the part of our deliberations under the week 11. What is your understanding, my dear friends, as of now about Ukrainian refugees in the light of ongoing deliberations, whatever we have been deliberating from the week one? What has been your understanding ever since? Because I think today is the 55th what you call day of the what you call war between Russia and Ukraine. If you can correct me. Yes, brother. Yes, Mr. Om, please tell me.
Sir, with regards to the Ukrainian refugee crisis, it is uh, pretty pretty sad to see the uh, affairs that has been going on between Russia and Ukraine, because uh, I was reading news about one child where his mother wrote an note uh, on wrote a note and said that that I'm going to my relative's house, and I'll be back soon. We will meet soon. And the that child had nowhere to go, and he was like the note was on his bag. The note was on his bag, and he was carrying around at the metro stations uh, all the way like he was just roaming around with that sticker note. Some reports were also there, like that it, certain like the parents have written uh, huge amount of things on the children's hands or bodies, and like stating that they will be back, they will be back. Some parents died, and one or two family members they did reunite all together. And uh, and so the people who have fled from their homes and going to nearby countries, and Poland and other Eastern European countries, it saddens about this fact that this should not have happened with the people of Ukraine. Like keeping aside the political differences between Russia or NATO or Ukraine, that is a different altogether matter. But uh, this saddens this saddens me personally, and I hope a proper solution comes for these people who should not have been treated like this. Should not have they did not deserve this actually.
Yeah.
Sir, adding to this, of course, it has been very sad to see. But if you put it in perspective as to the whole world, Ukrainian refugees have gotten way more attention than, say, for Syrians, example, merely because of the fact that it's Europe, and the fact that it's the center, the attention that goes on to something in which Europe is involved, or say US is involved, is much larger. And the whole world has come out to them, for them, and things like that. But the observation remains that this world still is a very Eurocentric in nature. Afghan refugees were there, Syrian refugees were there. No one cares about the Middle East and Asia and all of that. Rohingyas, I'm sure the West does not even know that something is wrong in this part of the world. So that being aside, of course, misery is misery anywhere in the world. But the idea is that since the world politics is so much inclined towards West, and so it gets more attention, which is again a problematic situation. So
Sir, adding to Saju's point also, sir, that there is the West do not like seem to like the West ignores about the other human rights violations that happen between in the Palestinian region, which is actually very saddening. And that is true that this world is Eurocentric, as stipulated by Saju.
Yeah, absolutely. Well, I immensely appreciate, and you have also increased your grades because of your critical thinking, and that critical thinking gyrates within the four walls of transparency, intellectual democracy, and within the culture of academic freedom. I buy your line of argument, Mr. Omja. I am equally what you call, adopting the line of argument floated by my learned friend, Ms. Sajul. Thank you very much, Ms. Sajul, raising a very, very pertinent what you call, dichotomy so far the refugee protection is concerned. And basically, both of you are talking of double standards in refugee protection. You have rightly pointed out, and this line of argument, in my individual capacity, Ms. Om and Ms. Sajul, I am having with the same amount of what we call of fodder, with the same amount of understanding, I have given it an expression of which is known as the doctrine of white constitutionalism. I perceive this entire dichotomy, double standard that you have pointed out. This is known as the idea of white constitutionalism, and this you have pinpointedly identified, Ms. Saju. Because if you take into account the causes, the factors behind the global north jurisdictions double standards, particularly the issues or towards the issues of refugees, then we generally find that there is a specialized, exclusive, and distinct approach which is being witnessed by the academics, students, jurists, in the context of approach that has been adopted by United States of America.
I would like also like
Some of the important what we call jurisdictions in the West. So that is very much discernible, because in this particular approach, what we have been witnessing, that after the conclusion of the Second World War, for the first time, the European nations are talking of dignity, civility, and supremacy and majesty of human rights of refugees. Even some of the politicians from Germany and United Kingdom has also voiced that it is not at all possible to witness this kind of brutality and barbarity in the 21st century. We cannot witness this kind of a decimation of the human dignity in 21st century. But these kinds of politicians did not utter a single word in the context of the Palestinian refugees, in the context of Syrian refugees, in the context of Rohingya refugees. Where was their humanity when these people were being displaced, and still they are being persecuted? at both the what you call of brand. They are being persecuted in the country of reception as well as in the country of origin. The thresholds of persecutions may be different, but the persecution has adopted some kind of a crisis perennial proportions. This should also be taken into consideration. And I am trying to deliberate this entire idea under one particular what you call understanding, which I call as white constitutionalism. And I have been writing. I have completed as many as two important more than 2 pages. First, I have going to write, and very soon you are going to witness it in the public domain, the idea of white constitutionalism, and thereafter I will turn it into the full-fledged research paper. Yes, you were saying something, Miss Sajul. I'm sorry.
Sir, no, that's all right, sir. First of all, looking forward to reading your paper for in terms of white constitutionalism. Also, sir, it brings me to a point that the issue is that the problem is first created by the European, like Eurocentric countries or whatever, and then we get problems like refugee issues, and then in turn it's like a vicious circle. As to see, like for example, in Afghanistan, Iraq, Iran, all of these countries, it was first the US invasion in the name of something something, and then later on it turns into a refugee problem. And then so the idea is that the world looks at it in the sense that no one is able to realize this, or no one is able to criticize this or what, because it's very evident that the issue is first created by the whites. And,
Yeah.
and I don't have anything against the race in general,
Yeah.
but it's almost funny to me when I observe whatever is happening in the world, that I don't know, why is there not more voice or more expression or opinion in terms of this, because it's very evident.
Yes. Yeah. Actually, you are absolutely correct. We are having, I'm sorry to say, and I apologize in advance because I never intended to hurt the feelings of my students and their ideological affiliations. I respect them. And as a educated person, this is my primary duty and responsibility, that I must respect the ideological affiliations and ideological, rather, uh, whatever the philosophical roots my students have been espousing. I should be very, very reverential to those very roots or to those affiliations, and I must respect your ideas, because this is the history of ideas that really tells us that we should be very reverential, very, very respectful to those very ideas. But today we are basically having a new vista of democracy. And in this, new vista of democracy, it is in each and every geopolitical entity, there is no exception at all. Basically, everybody is talking human rights, everybody is talking of human dignity. All of us have been, talking of, judicial review. All of us have been what we call, talking of transparency, good governance, rule of law, human rights, social justice, and constitutionalism, all with its all manifestations. But all of us are, talking of. But there is a discernible difference in the second decade of the 21st century, and including that is going on in the third decade, particularly at the beginning of the third decade of the 21st century, that is 2021 2022. What we have been witnessing, Ms. Sajul, that democracy has become a majority driven democracy. If Christians are saying something as a majority, that becomes the manifestation of democracy. If in Germany any racial minority is voicing their, concerns, that is not at all appreciated or tolerated. They are branded immediately as anti-German or anti what you call, national. Because their views are at variance with the majority community. So we have been witnessing a new kind of a democracy. Today, or in other words, let me put it like this, Mr. Rom, that today's, democracy is exclusive democracy we are living in. But democracy has always, because as a student of international law, as a student of, law, I have been taught by my learner teachers. When I was studying political science and I was studying, democracy, then I was taught by my learner teachers in my graduation days that the democracy means inclusion. And today what I have been witnessing while occupying on the other side of the table, that the democracy means exclusion. So this is a democracy, to me as a student of law, is a journey that starts from inclusion and goes up to exclusion. And after exclusion, it would be silence. So what kind of a journey we have undertaken? Democracy, it's a democracy induced, I should say, democracy induced alienation, exclusion, silence. If Mr. Om is making a point and saying something, then it is okay. But any kind of a difference with Mr. Om, that may result in some kind of a, exclusion. That may also result some kind of a what you call an act of what you call of subterfuge, an act of national chicanery, an act of what you call of treason. So this kind of a labeling, this kind of a branding that is going on, and no geopolitical entity today can claim that it is having some kind of a distinction. No. All the democratic regimes are sailing in the same boat. It is the regime dictated line of argument that is occupying the central space in the national priorities. Opposite voices, dedicated, patriotic, nationalistic, opposite voices are not getting enough space. Their space is shrinking like anything. Whether it is United States of America, whether it is European nation states, whether it is African nation states or Afro-Asian nation states. We are not in a position to appreciate a different line of argument. And this has resulted and likely to result and will result definitely. Because if there is no cross-fertilization of thoughts, if there is no what you call, alternative views, if there are no perceptions, if there are no, criticisms, I am talking of healthy, fair criticism, my dear friends. If these kinds of, fair and healthy criticisms are not allowed, then we are not going to have a better what you call, notion or a, I mean, we are shutting down the doors to what we call, innovations, cross-fertilization of ideas, inventions, discoveries. Everything is going to be or likely to be reduced into a vacuum. And who is going to fill that very vacuum? Only the alternative voices can fill that particular vacuum. So that is the situation, and this is what we have been witnessing in cases of refugee reception. Because at international level, what we have been witnessing. Let me take further the argument that has been floated by Ms. Sajul. We have been witnessing race. Why the Western nation states have been voicing their concerns about Ukrainian refugees? Because they identify themselves with the race of Ukrainian refugees. They identify with the location of the Ukrainian refugees or Ukraine. They identify, my dear friends, they identify when they have been deliberating the problems of Ukrainian refugees, my dear friends, the Western nation states have been identified themselves with a humanitarian or Western humanitarian discourse. Because the idea of constitutionalism, the idea of European values, which we have already deliberated, the idea of American exceptionalism or the constitutional exceptionalism, which we have deliberated significantly in the classes of the comparative constitutional law of South nations, they generally identify themselves with this kind of a what we call value system, which is also practiced by the Ukrainian people. And the most discernible and distinct point which comes to my mind is, and that is, my dear friends, is race. Their geopolitical setting and how they have been managing and regulating the global humanitarian assistance debate. Because the Europeans and the North Americans, my dear friends, more what we call conveniently identify with the white Christians than with the dark-skinned what we call Muslims and other what we call or blacks in Africa. That is the problem. Because we should not forget, my dear friends, no geopolitical entity, no state behavior is free from some kind of religious implications. Religion has always been there to guide the national policies or the behavior of the state. If we are talking of a Christian majority state, the Christianity has been dictating the behavior of the state. If we are talking of the Muslim majority nation states, then it is the religion of Islam that is reflected in the behavior of these nation states. So we cannot forget, we cannot deviate from this kind of behavior, particularly in the context of Ukrainian refugees, if we are going to what we call deliberate. Because Ukraine has always been the part of what we call of European nation states. Geopolitically speaking, my dear friends, the entire what we call Ukraine serves as a very important argument for European nation state security narrative. And that is why Western nation states, they are what we call supplying each and everything. And see the dichotomy. No European nation state has stopped despite the lot of sanctions which have been clamped against Russia, but the European nation states did not stop buying oil and natural gas from the Russian Federation. They are still buying, but at the same time, United States of America is also supplying anti-tank missiles to the state of Ukraine. And the Ukrainian armed forces, they have already decimated and destroyed as many as more than 600 tanks of Russian Federation. And that was made possible by United States of America and its, weaponry supply chain. Because the most advanced anti-tank, missiles have been, supplied. So you can very well understand how they have been what you call, playing their roles. This should not be forgotten. But at the same time, Ukrainian crisis has presented a very, very important opportunity to the entire what you call, academic fraternity, think tanks, stakeholders, experts on foreign policy, international relations, and international law. How state have been, behaving, and what kind of, discriminatory practices have been adopted by the, global North jurisdictions towards Rohingya refugees, Palestinian refugees, and Syrian refugees, and other what we call, communities, particularly the Roma minorities and other, ethnic minorities. Yes, Mr. Rom.
Sir, my question is like, as you said about like inducement of democracy within the country, sir. Like this has led to refugee crisis as well. Like if we see about the 1979 Soviet-Afghan war, it was quite evident that there was a, a war of ideologies between the United States of America and the Soviet Union. And sir, so it seems that there has been an imposition of democracy by the West in the Western Asia, like in the countries like I can say like Central Asia. So we can say Afghanistan. Then we can say about the Western Asian countries as well, like Iran, or I think now Iran, Iraq, like America, sir. America or the Western countries have been trying to like impose their ideologies in some way or the other against the uh, against such certain countries to which their interest lies. And so this was same with the Soviet Union as well.
You are absolutely right. Yes, absolutely correct.
And sir, adding to this, like if there are countries where, sir, if sir, it's my opinion, I can be 100% wrong here, but in my opinion, if democracy or communism is not functional to a state where the practice does not the practice of democracy or communism does not happen, why to impose a certain kind of ideology that is not ours? It's not ours. Like our way of practicing the ruling or practicing our ideology is different from what the West has been practicing. So, sir, why it's the imposition of democracy or communism or whatsoever maybe, so that it leads to a huge refugee crisis. And sir, if we talk about Islamic countries as well, in the Western Asia, since time immemorial they were not in practice to certain democracies, certain practice of democracy which the West has been imposing on them.
Yes. Let me supplement your line of argument. Armed conflict or war in Ukraine, my dear friend, that is equally important, and that should also be understood as a crucial geopolitical background. That has also put United States of America against Russia while reviving the Cold War spirit of ideological confrontation. However, this entire ideological confrontation has been presented as an innovation or innovative argument as democracy versus autocracy. if you take into account one of the most important portion out of this cocktail, and that, that portion ultimately setting certain important what you call goalposts, or setting some geopolitical identities like China. It is also axiomatic from, or axiomatic motivation, I should say, of the United States of America, that by indulging and supplying arms to Ukraine, United States of America has also, it should be taken as one of the most important implications, US has also warned China via what we call, Russian Federation, that if it attacks what we call, Taiwan, because that controversy is also going on, if China tomorrow going to emulate the Russian Federation, what we call, military campaign against what we call, Taiwan, then it will face a unified national resistance. And that has been what we call, reiterated by military and diplomatic support from the Western nation states. And at the same time, that at all level, the minimum will what we call, minimum amount of, or minimum quantum of sanctions would be very punitive, and that is going to what we call, damage the Chinese economy. So the United States of America is basically carrying out many important what we call, objectives so far its military adventures are concerned, or the military support is concerned in this particular hostilities. At the same time, my dear friends, United States of America volatile, I should say, or with a volatile understanding, particularly so far the current stage is concerned, the current stage of military engagement is concerned, it may also reflect some kind of a divide, some kind of a divide among foreign policy advisors in Washington, who have been who have been favoring some kind of a diplomacy to end the Ukrainian war, and those who give some kind of a precedence to humiliating Russia and Putin, even at the cost of what we call extending war indefinitely. Because it is axiomatic from the statements of the Joe Biden administration that the United States of America does not support an early conclusion of the ongoing military conflict between Russian Federation and Ukraine. So therefore, some other vital questions are also involved. Because when we are talking of the different kinds of occupation, when we are talking of some kind of a creating some kind of a categorizations like the good occupation or the good aggression or the bad aggression or the good occupation or the bad occupation, then they have created a new kind of a class. Because if you take into account the entire state behavior of the United States of America, particularly in the context of Afghanistan, then it was the same United States of America which has created a militant Islam and moderate Islam, a militant Taliban and moderate Taliban. So in case of Ukraine, the United States of America is intent to create the bad occupation or the good occupation. Because at the same time, they have to justify, the United States of America has to justify the occupation by Israel in the Palestinian territories or of the Palestinian territories. So this is the further what you call implication. Yes, you were saying something, Mr. Ram.
Sir, my question is we uh, in currently we are seeing that there's a debt trap policy that the countries use. Sir, we are witnessing the situation of Sri Lanka, where the economic situation is uh, is very deplorable. So, sir, and now when the government does not have the amounts to pay to its officials or to provide the amenities to its citizens, and this can lead to a this may lead to huge refugee crisis if the situation goes on for long. So, sir, can this be considered in the laws of in the laws of refugee, that they can be considered as refugee because they were subjected to this economic disparity due to debt trap policy?
Yes, Ms. Sajul, would you like to respond?
I'm so sorry, I missed the question that Om was posing.
Yeah, please.
Om, could you please repeat the question?
Yeah. My question was that the countries have been using this policy of debt trap policy, um, and we have seen the situation in Sri Lanka, which is very deplorable in terms of economy, and the people are not getting the facilities that the citizens of Sri Lanka are not getting the facilities that they are entitled to, and there is a huge economic disparity between these two entities, the government and the citizens. And now, if this crisis goes on for long and the people do not get what they are entitled to, and there will be a huge crisis, and this may lead to a refugee crisis as well. So can this be considered under the convention of law of refugees? That is what my question is.
All right. As of now, what opinion I have is that I don't think Sri Lankans would be considered a refugee as of this situation, as of today, present. Merely because of the fact that okay, there's an economic crisis, but when people start leaving uh, in a situation, maybe then. But if you look at the very layman definition of what a refugee is, not going by the international law standards, it is wherein a person is forced to leave due to a war, persecution, or natural disasters, right? So economic crisis as of now has not been a criteria to actually force people to leave, and then maybe them becoming a refugee. And also I am actually confused with regarding this, because see, if they do not have enough money to actually stay afloat, so they would be leaving by some illegal means, and in entering and through any illegal means into another country would anyway not be a good solution, and would not be actually categorizing them as a refugee. So I in my head is now a paradox, and
Yeah,
I'm very confused.
yeah. No, no, no. There is no confusion. There has been a significant clarity. Let me supplement. Yeah. Mr. Rom, I must congratulate you that you have raised highly paradoxical, polemical question, and that really warrants our attention. My dear friends, if you take into account the various researches which have been in recent years put in public domain, and this reminds me of a very important and significant research that is there in public domain, and that was contributed by Professor Alexander Betts of the University of Oxford. He came out with a book And in that very book, he has coined a new kind of what he called expression. He favored a new expression in place of the expression which is today known as a refugee. And that expression is known as survival migrant within inverted commas. Because there are number of calamities, there are number of what you call or insurmountable cataclysmic calamities, which ultimately have been decimating the existential survival of the humanity. Whether we are talking of today the soft law, whether we are going to discuss protections under the guiding principles, whether we are going to discuss protection of RAMs, RAMS. This is a word in an abbreviated form. I have coined the protection of RAMs. I have already submitted one of the articles that has been published by the Advanced Studies Center of the University of London. So that idea of RAMs, R stands for refugees, A stands for asylum seekers, M stands for migrants, S stands for stateless. The security of RAMs, I'm not talking of, the protection of refugees, but all the, group of people who are on the, move, and they have been confronting, fleeing, and evading refugee-like situations. So the case which Mr. Ron, you have raised, that comes within this particular, purview. Because the economic migrant, they are bound to live in refugee-like situations. They are going to be deprived, or they have been deprived because of the economic policies. I am not talking of the foreign policies. I am not talking of diplomacy. I am not talking of the fiscal policies or the fiscal relations, fiscal external relations of the government of Sri Lanka with other nation states. Because in the wake of charting new routes in the name of the pristine route of silk, or the silk route of the ancient time, and that these routes are being revived with more routes by the Chinese government as the Belt and Road Initiatives, or BOR, which is popularly known as. So they have adopted a policy where under the government of China is doling out a lot of what we call of debts to the developing nation states in the name of development, and they are entering into an agreements, and it is one of the conditions of those very agreements that there would not be any kind of arbitration without the consent of government of China, and they are also adding some clandestine conditions or the suspicious conditions, and these conditions, again there is a clause that these conditions would not be divulged to other nation states if there are some kind of bilateral treaties by the same government. It means the Sri Lanka cannot divulge the contents of conditions, whatever the conditions have been there between the bilateral agreements between China and Sri Lanka. So it's a very, very discriminatory clause. Even if the governments are transacting something bilaterally. So the debt trap policy has ultimately what we call weakened and emasculated the national economies of many countries in Africa as well as in Southeast Asia. Recently, one of the most important and vocal leader has been, and it was the Malaysian leader Mahathir Mohamad, who ultimately rescinded many of the bilateral agreements and also reviewed some of the agreements signed by the previous regime with that of the government of China, or China and Malaysia. So the economic migrants, it is generally said about migrants that they are basically preferring migration without any kind of a duress, without any kind of a, coercion, without any kind of a, compulsion. Migrants generally move from one place to another, or if they are crossing international borders, they are crossing in search of the greener pastures because of the economic well-being. But in case of Sri Lanka, a novel situation has erupted. And it's a man-made what you call situation. Because of the economic policies of the government, because of the taxation policies of the government. But Ms. Tajul has also pointed out very correctly, Ms. Rome, that so far international refugee law instruments are concerned, we do not have this kind of a criteria, economic criteria, to qualify as a refugee. But if you take into account the entire umbrella of protections which have been agreed, which has been adopted, and if you take into account the entire spirit of human dignity that is going to be, and that has been, and that is a pervading line of argument that pervades entire what we call international treaty obligations, protection regime, and that is available in the form of the 9 core international human rights treaties, including international refugee law instruments. Then economic migrant requires to be protected. It is the constitution of the Sri Lanka. It is the constitution of US. It is the unwritten constitution of UK. It is the written constitution of the basic law of the Germany, and it is the basic law of Saudi Arabia. It is the constitution of India, and it is the constitution of Pakistan or Bangladesh. Even economic migrants are also protected. When we are talking of, if you take into account the liberal interpretation of the definition that has been provided by the 2 important instruments, a Eurocentric instrument in the form of 1951 UN Convention relating to the status of refugees, and 1969 OAU Convention relating to the specific aspects of refugees in Africa. At the same time, the Cartagena Declaration of 1984 and Universal Declaration of Human Rights. If you are going to have the cumulative impact of these instruments, then we are under an obligation to protect, my dear friends, economic migrants coming from or coming out of Sri Lanka. It is the responsibility of the international community that the international community and the Bretton Woods institutions must also declare some kind of a economic moratorium. And the present dispensation, headed by a family, the Rajapaksha family, they should immediately, or must be what we call they must tender their resignations. And a government of the national unity must be installed in Sri Lanka. That must be what we call oversee, at the same time it must steer this economic crisis. And in the long run, after some reasonable time, stipulated in the national understanding document, likely to be, or any, if there is a likelihood of this kind of a argument, then they should also envision and stipulate a time frame within which they are going to hold general elections. So that should be the approach. Otherwise, so far, though I have exceeded my brief, but so far your question that is limited to economic migrant, and because of the economic criteria, because of the economic grant, if somebody is impelled to what you call leave or displaced, then and they are also confronting or what you call, placing a refugee-like, situation, they must also be protected. Yes, under international refugee law, my dear friends, this is on the basis of my liberal interpretation. I am of the view, yes, they should be protected. If I happen to be an RSD, refugee status determination official, I will make a recommendation. Yes, under such and such, law, under such and such, because this is the line of argument, and there is a school of, thought. There is an emerging scholarship in the form of a, professor, what you call, uh, Gorlick, Professor Gaius Goodwin, Professor Hathaway, and more recently, the Professor Alexander Batts. They are arguing, they are also undertaking this kind of a, line of argument. Yeah. Anything else? Well, thank you very much. Tomorrow we are going to discuss one of the most important, though all the issues are important, but any one issue we are going to take up. I may discuss, I haven't decided what I am going to discuss, but I am, studying a lot of, issues. And tomorrow we are going to discuss either Palestinian refugees or Ukrainian refugees or, Syrian refugees, or simultaneously or cumulatively, we may discuss all the, issues or more than one issues that is plaguing the international community in the arena of international refugee crisis. Yeah, thank you very much for being with me. Most welcome. I am immensely thankful to Ms. Sajul as well as to Mr. Omjha for your very plausible, very reasonable interventions, which ultimately enriched the amount and the level of our deliberations. So thank you very much, my dear friends.
Sir, I'm also very
Thank
grateful
you so
for
much, sir.
this thing that you continuously engage us with your beautiful lines of explanations and arguments in this refugee
Thank you, brother.
series. And sir, we actually get very engaged about this, and we deliberate and we
Yeah, thank you very much for your
deliberately.
kind words. And your kind words, if you are my students are saying something, I take them as an enhanced what you call level of my accountability. I feel that I should be more dedicated, more what you call full of professionalism, full of energy, and I should be very forthcoming in my submissions. So thank you very much for your kind words, for your encouragement, and I believe and I promise that I would be more unflinching, more unwavering in my dedication. So far, my submissions of an academic work or inputs are concerned, or academic nature is concerned. So thank you very much for being with me. And
Also, sir, you're so patient with us. I'm so grateful about that.
thank you,
Thank
ma'am.
you so much, sir.
Thank you. Thank you. Thanks a lot for your
Have a
support.
nice day, sir.
Sir, are you coming to the campus this week?
I will let you know. As of now, I am not there, but I will definitely I will make a visit, because without visiting the campus, uh, I think we can't survive. But definitely, I will let you know. Thank you very much.
Thank you,
Thanks a
sir.
lot. Enjoy yourself.
Thank you, sir.
Thank you, brother. Thank you, Minsa.